a secret that maybe sometimes, especially trust lawyers, overlook and don't share with you, is that a revocable living trust will not accomplish that result. If there is a revocable living trust, and even if it says it has a supplemental needs trust in it for the surviving spouse, the state of Washington will not honor that as asset protection. In other words, with a revocable living trust, if the spouse dies and they say, I want my spouse who's living and who needs care to be able to receive these assets and be eligible for care, they will not. All of those assets that are countable assets will need to be spent down. So one of the things about revocable living trusts is why they are so popular is that they will avoid probate if they're done right. But in the state of Washington, if you take that route versus taking a will with this trust in it, then you're not going to protect assets for your spouse once you're gone against long-term care costs. So yes, there will need to be a probate, but in the situation I described of John and Joan, you're protecting half, if not all, of the couple's assets because you have a will and you're maintaining Medicaid eligibility. You cannot do that in Washington with a revocable living trust.